Good morning, everybody, and thank you for joining us today. We're the Freeth Natural Capital legal team. Myself, Penny Simpson, and Kirsten Roberts and Richard Broadbent, we're all here to present to you this morning on some tips for developers when buying natural capital units. That's principally biodiversity units or nutrient credits that we're talking about today. This is one of 4 webinars. We've done 3 already. We've got them on the screen now. And if you'd like to catch up or haven't seen the recordings of those, you can use the link in that slide to reach them. And we will be recording this webinar and uploading it with the others on that website link as well. Okay, what are we going to cover today? We're going to cover basically tips for people who want to buy biodiversity units. That's biodiversity units under the mandatory biodiversity net gain regime. Or buying nutrient credits. So principally this webinar is directed at developers who are needing those units or credits to successfully build out the developments for which they have planning permission. What we're going to be looking at is checking at what you're getting from the supplier of the units. How do you check whether you're getting something that's worth the money you're paying for it? And then secondly, what would you expect to see in an agreement under which you are purchasing those units, and what kind of provisions would you expect to see, and how might you negotiate those provisions? So I'm going to hand you first of all to Richard to deal with the first point, which is checking that what you're getting is what you're paying for. Thanks, Richard.
Great. It's lovely to be with you all again. Thanks for everyone for dialing in. So I'm just going to do a little bit of scene setting, and then I'm going to get it into some tips on due diligence for these natural capital credits or units. And this is something we do quite a lot here at Freeth. So this is just a bit of scene setting here. So you've got some relationships going on, which you should be aware of. So obviously, developer has relationships with a local planning authority. They're putting forward their development. They've got agreements going in place for the Section 106, which they'll have with local planning authority for different parts of the development. That may include, for example, on-site biodiversity units. You may be creating on-site biodiversity units, which, if they are deemed significant by the local planning authority, will need to be secured through a Section 106 agreement, through a planning condition, or through a conservation covenant. So that's the kind of relationship that's going on there. But if off-site biodiversity units are needed, or if you're in a zone that's affected by nutrients and needs nutrient neutrality, then you can go off-site and seek people in the market who can provide you with nutrient credits or with off-site biodiversity units, and that's another set of relationships. And what Kirsten and I will do is talk you through those and who you're asking questions of, and how you deal with these. Okay, so a bit of scene setting there. Let's look at the first example then. So let's look into biodiversity net gain. So there's sort of 3 elements of biodiversity net gain to achieve that 10% net gain that you need as a developer. You can do it on site, as I just mentioned. Or if you can't get your gains on site, then you can go off to the off-site market to private landowners who are creating habitat banks. So you can buy the biodiversity units you need from them. Or you can buy, as a buyer of last resort, statutory biodiversity credits from the government. The unique thing about biodiversity net gain is that it's got its own regime, its own rules, and these are derived from the Environment Act 2021. There's a statutory metric that applies here, which undergirds the calculations that are carried out of the on-site biodiversity and the units that you need. And importantly, in this market, to give it integrity, off-site biodiversity units are registered on a biodiversity gain site register, which is administered by Natural England. So this regime sort of stands on its own feet, got its own legislation, its own rules under the metric, and it's got its own register that works with it. And I'll contrast that a little bit later on when we talk about nutrient credits. Okay, so if I am buying off-site biodiversity units, what sort of top tips should we be looking at here? Well, the whole idea with this regime is that there is a register that sits with it, and as I said, that gives integrity to the market. So a simple due diligence exercise for a developer would be okay, I'm buying biodiversity units from someone. Are they registered? Because you can only work with registered biodiversity units when it comes to mandatory biodiversity net gain. So what you can simply do is go to Natural England's register. It's free to access it. You click on it. I find it quite hard to navigate, if I'm being honest with you, but with a little bit of practice, you can make sense of it. And you go on there and you check whether the habitat bank that you're looking to buy biodiversity units from is registered. And then you check underneath that, it will tell you what kind of units it's got, and you can check that to see if it actually has the units that you need of the biodiversity of the habitat types that you're after. So that's a sort of simple due diligence, and really you can leave it at that. There's provisions in place that try to ensure that whatever's put onto the register is being vetted properly, either by the local planning authority if it's secure through a Section 106 agreement, or by the responsible body if it's secure through a conservation covenant. And Natural England will do its own checks on that on applications before they put them on the register. However, some developers who we work with, developers who are concerned about their reputation, about their brand, or institutions, for example, academic institutions who may come under scrutiny from their students, for example, about the integrity of the regimes of the schemes that they're purchasing units from. Well, they might want to do a bit more in-depth due diligence, and that means really looking beyond the register. And here, I mean, checking the credentials of the organization that you're buying the biodiversity units from. You know, have they been supplying units for a while? What kind of credentials do they have as an organization? What's their reputation? Have they been around for 5 minutes, or are they, or do they have some history and success in the delivery of habitat banks? So, you know, check who the landowner is, check who's enforcing the obligations. Is it a local authority? Is it a responsible body through a conservation covenant? If it is a responsible body, you know, who are they? How recently have they been designated by the Secretary of State? Check whether they've already started allocating biodiversity units, because if they have, that gives you confidence that that they're operating correctly. And you may even want to go beyond that and check whether there's any double counting that's going on in the sale of those biodiversity units to make sure that this is actually a legitimate scheme. Now, those are all plus things. That's where you have you know, concerns that you know, risk management, that sort of thing, reputational management that you want to think about. But that's the sort of more in-depth due diligence that you can do.
Richard, as you say, the more in-depth due diligence is almost on a voluntary basis
Yes.
for biodiversity net gain, but we're acting for lots of people buying sometimes water credits, sometimes nitrate, phosphate, and even not buying credits in units where they're paying for access to linked land. Can you go on to talk to us about that, please?
Exactly right. So that's so moving on then from biodiversity net gain. So biodiversity net gain's got its own rules, its own regime, and that's fine. But what if you're buying nutrient credits, say, and how does that differ from biodiversity net gain? Or, as you said, buying water neutrality credits. Now, water neutrality has been dealt with in the Arun Valley, according to recent announcements by the government. But theoretically, it's an issue that could affect other places which have stresses on water supply. Also, we've seen credits for the sale of functionally linked land. That's land which is functionally linked to, for example, SPA. So that's special protected areas for birds. The birds are roosting, breeding in the SPA, but they move around the landscape around it to feed on. Well, that land that they're feeding on is functionally linked, ecologically speaking, to the SPA in question. Well, we've seen credits for sale there too. Now, with those regimes, nutrient neutrality, water neutrality, functionally linked land, we're dealing here now with a different regime. We're dealing here with mitigation in respect of impacts on protected sites within the National Site Network, or as we used to call them, European sites. So European sites derived from the Habitats Directive and the Wild Birds Directive. And this is a regime which is transposed from European law into English law through the Conservation of Habitats and Species Regulations 2017. And the mitigation that you're buying must comply with that regime. And it's a much stricter regime. It's meant to be strict. It's the most strictest form of protection that we have for habitats in this country. So the legal tests which the mitigation must meet must be those legal tests as per the case law for the Conservation of Habitats and Species Regulations, or habitats regulations as we tend to call it. And that means that the competent authority, that's the decision maker, must be certain or convinced there'll be no adverse effect on the integrity of the site because of this mitigation. So certain and convinced, that's the kind of language that's used in this context. And that means that where there's no reasonable scientific doubt remaining as to the absence of those effects. And that's why it's quite a hard standard to meet. If the competent authority can be certain of no adverse effect on the site integrity, then the plan or project, or in this case, the development can proceed. So that's the language that's used here. So, and it's precautionary in nature, hence that language of being certain and convinced and no reasonable scientific doubt remaining. So the mitigation really must be quite sound. That's what we're, is that issue here. Well, what does that mean? Well, if you're checking whether the mitigation is sound, that means, can I be certain, scientifically or technically speaking, that it will deliver to the extent that the decision maker can be satisfied beyond reasonable scientific doubt that the mitigation will succeed. Also, is it legally secured? Because only if it's legally secured can the decision maker be certain that it will be delivered. And then finally, financially certain. Mitigation needs to be financially viable and operate. And if we're dealing with nutrient credits or water credits, as water neutrality credits previously as well, you're looking for the mitigation that's going to last in perpetuity, so the lifetime of the development, which is usually calculated as around 90 years. So that's the sort of level of scrutiny that's applied here for the competent authority. And if the competent authority fails to check this properly, or if the mitigation falls below this, well, then the decision making over the development, the permission of the development is vulnerable to the judicial review challenge. So that's what you're trying to do here. You're trying to do due diligence that avoids that judicial review challenge in essence. Okay, so what
also, because when you go as the developer, when you go to your local planning authority and say, I've satisfied my conditions attaching to my planning permission, you will get challenged and you'll need to provide this information. Oh,
absolutely. So exactly right. You need to know that for these purposes, that the scheme that you're buying into is it works. It meets these standards. Okay, so what does that look like here? Well, let's in this context, quite frankly, there's no simple DD option here. There's no register like there is for biodiversity net gain, and you can't assume that these checks have been carried out by other people. For me, if I'm acting for a client who's looking to buy nutrient credits or other things in this area, I'm going to be looking beyond that, and I'm going to be asking myself those three questions framed in those three ways. So technical or scientific in the first one. Has Natural England confirmed that it's happy with the scheme? Has it said that it's a legitimate methodology that works, and that they're happy that it works in these circumstances, given its location within the river catchment, and so on? That's the kind of thing I'd be looking at based on my experience working in Natural England on these sorts of schemes, and sort of bearing in mind what they would need. Next, I'm going to see if there's a legal agreement in place and how that operates, and check that and see how strong that is. Financial checks, less of a concern for my developer clients, because, well, it's for the scheme operator to ensure that they've done their sums correctly on that. However, I would do a sense check on that. If the prices that they're suggesting are very low, and you've got a 90-year scheme here, I would be concerned about whether that's viable or not, and may probe into that a little bit more.
I suppose the issue there, Richard, is if and I'm going to go on to talk about the sort of two stages in which people often buy these units and credits. But when it's credits, if you've paid a deposit, and in between paying the deposit and then calling for the unit to be transferred to you, and you're going to pay the balance, if in that gap the scheme goes into insolvency, then you've wasted your deposit money. And perhaps even more importantly, it's going to cause you a timing headache, isn't it?
Absolutely, because then you have to find these credits from another source. you know, and that could put you back if there's a failure supply around that. So, you know, those are the, and you know, even lawyers I speak to on the other side in deals, they sort of confuse biodiversity net gain and nutrient neutrality. They sort of say, well, you know, it's similar principles. No, they're quite separate principles, and that's why it's important to look at these three areas to make sure the mitigation is indeed viable, quite frankly. So those are my
Richard,
yeah.
Richard, on the second legal one, legal checks, I think we'd cover off double counting and things like
Oh,
that,
for
wouldn't
sure.
we, in that legal check?
Yeah, absolutely. Those sorts of questions that we're asking ourselves at biodiversity net gain without deeper due diligence, you know, those are the kind of things you'd be looking at here, but through this prism of technical, legal, and financial.
And just to be clear, we have done due diligence and found real problems in schemes.
Oh,
So
my
and then
goodness
told
me,
our clients not to buy the credits. So, you know, this is not just a process. This is actually comes down to checking that what you're buying is worthwhile buying.
Oh, absolutely. We've had a developer client given a cost estimate, you know, for tens of thousands of pounds for credits. And when we've done these checks, not only was there no scheme, you know, up and running, it was not legally secured. It was still waiting for its Section 106, and Natural England hadn't given its opinion on whether it was a viable scheme or not. You know, so absolutely, it was the right thing to carry out those checks there. Otherwise, well, you don't know what you're buying, and if you don't know what you're buying, and you've got to meet these kind of tests, well, that's a big problem.
And I suppose also, not to bang on about timing, but to bang on about timing, for another developer client, they were all set to pay their deposit, I seem to recall. And then it became clear that the scheme wasn't going to have the credits ready within the timescale our client needed them. It was going to be about 3 months after they'd intended to put sort of shovels in the ground.
Yeah. So yeah, all more reason why you know, we should work in these you know, look at these things in more detail.
Cool. Thank you, Richard. So now I think it's over to me. And I'm a contracts lawyer, whereas Richard and Penny are environmental lawyers. I'm a contracts lawyer, so that's why I act for people who are selling these units and credits, or the intermediaries brokering the sale of them, or guys like you guys, buyers wanting to buy them. So back to basics, as I say here, there can be 3 people at this party or just 2. So you as the developer might have found your landowner seller, or you might have gone through a broker, or it might have been the seller's broker who contacts you. Next slide, please. But even if there is a broker involved, just, you know, a little red flag, you need to be buying the units or the credits from the landowner, from the party that's entered into the Section 106 or the Conservation Covenant. And the reason for that is a lot of brokers get confused and think that because they have a right to sell the units or credits, that's the same as owning them. No, it's not. It's like your middleman selling a car on behalf of the person who actually owns the car. So you need to make sure that your sale and purchase agreement for these units and credits is directly with the person who actually owns them. Otherwise, you're not buying anything. And I've mentioned at the top of that slide, allocation agreements. This is all relatively recent, this commercial venture of buying and selling these units and credits, but a lot of commercial norms have already developed. One of them is that we call the sale and purchase agreement an allocation agreement. So if you hear that term or terminology, it just means the sale and purchase agreement. Next slide, please.
But that's a really key point, isn't it, about the landowner? It is sometimes that trips people up, making sure that they are actually buying it from the legitimate, you know, party.
Yeah, and that can be true also if you've got a long-term tenant of the land, and therefore it's the tenant creating the units and credits. You need to check behind, well, what if that lease is forfeited?
Yeah.
You know, do those credits and units still exist? You know, so as soon as you realise that the person who signed the Section 106 or responsible body isn't the name on your allocation agreement, that's a red flag for you to do some more checks.
Yeah.
So what we see also in terms of these allocation agreements is they're either a one-stage affair or a two-stage affair. What do I mean by that? A one-stage affair is where you, the developer, just pay the lump sum on signature of the contract, in return for which the seller transfers ownership of the units and credits to you. If it's BENG, biodiversity net gain, they'll also be recording that allocation of those units in your name on the Natural England Register. If it's anything else, any other type of credit at all, they'll be issuing you with a certificate. And that's your evidence that you can show your local planning authority to say, hey, look, I've satisfied the condition attaching to my planning permission. It would be normal in those allocation agreements also for the seller to agree to provide you with some reasonable assistance in satisfying any additional queries that your LPA has. So that's a one-stage affair, very straightforward. But what we more often see is the two-stage affair. And that's where you know that at some point in the future, you're going to need some units or credits, and therefore you want to reserve them, but you don't want to shell out all that cash right now because you don't need them right now. So what you do is you go and find your seller and you reserve those units and credits to you. You pay a deposit, normally around 10%, and then at a later date, you will pay the balance. And it's only at that second stage that ownership of the units and credits transfers to you. And therefore, only at that second stage can you go to your LPA and say, I've satisfied my planning permission condition. Next slide, please. So as I mentioned, we've been buying and selling these units and credits for about 3 years now. I'd say we've been in this game longer than most law firms and as long as anybody else. And because we act for the sellers and the intermediaries and the buyers, and therefore see these transactions in the round, we can sort of genuinely talk to you about what's normal, what's not normal. So I mentioned that normally it's a two-stage process, the buying of the units, and you would pay a deposit. We normally see that deposit, it's about 10%. When we started off, it used to be much more variable, 5%, 15%. These days, it always seems to be 10%, with a balance of 90% being payable on completion when you actually need to buy sorry, not on completion, at the point when you call for the units and title in them transfers to you. We often see as well that that deposit is very much linked to a reservation period. So the seller isn't saying, you pay me 10% of the value of these units and I'll hold them for you forever, come back to me in 10 years. Well, not generally. What it's saying is I'll hold them for a short period, because if you're not going to pay me that 90%, I'm going to go and sell them to somebody else. So that reservation period, often about 3 months, we see 6 months, I've seen 12 months. Very recently, I saw 10 years, but that was a very extraordinary deal for millions and millions of pounds worth of biodiversity net gain units, a very different kind of deal. What we often see as well is that the developer has the right within that initial reservation period to go back and say, actually, I need to extend my reservation period. And for that, you would expect to pay another deposit, say another 10%. And again, that will come off your overall balance, but it's sort of front loading how much cash you've had to pay at the beginning.
We've talked about this in previous webinars, but it's legitimate to do that because you are taking off your units from the market, so you can't sell them to anyone else, and you should be rewarded for that with a, usually a non-refundable deposit.
Yeah, exactly. Yeah. And I mean, equally from the developer's perspective, things change. Often it's longer to build out than you're expecting, or, to get ready for that stage. And therefore you don't want to be paying the balance yet. So there's a bit of sort of jivvying around between the seller and the developer to be done there. I've put a question mark after the words deposit refundable. The answer is hardly ever. So if it's biodiversity net gain units, that we don't see that deposit is ever refundable. So if you don't come to your seller within that reservation period or an extended reservation period and ask for the units to transfer to you, you will you'll lose your exclusivity over those units and you will forfeit your deposit. They just keep it and then they get to sell them to somebody else. The only circumstances in which we see from a commercial perspective that changes is with regard to the nutrient credits and some of the other credits, where developers will negotiate for themselves into that allocation agreement a right that if there's a change in law, which means they no longer need those credits, then perhaps the deposit is refundable in those situations, or maybe 50% of it is refundable. And we also see in relation to the credits in particular, where Richard was saying you have to do a lot more due diligence as to whether these things actually exist. If it turns out the seller hasn't got credits to sell you, it hasn't managed to sign its Section 106 or conservation covenant in time, then you'd get your deposit back.
Yeah, I mean, that makes sense.
Yeah, thank you.
We're getting close to
yes,
time,
speed
so
up, Penny. Good bell ringing. Assignability, I get asked a lot about, you know, if I decide I don't need these units or credits, can I sell them on? I would say it's quite narrow when you can do it. With biodiversity net gain units, very difficult to reallocate them to somebody else. But what you should try and negotiate into the contract is that if you sell the land, you can sell the credits or units with the land, and hopefully also negotiate into the contract a right to use those units or credits on your other developments, or other parts of the development, just to give yourself a little bit of flexibility if you've already paid that deposit, or indeed the whole balance. Next slide, please.
We are on the next slide.
Oh, sorry. Protections for buyers, yes. So just very quickly, protections for buyers. The protection you don't need is to have an allocation agreement which lasts as long as the landowner's responsibilities to maintain the land and the enhancements it's created, perhaps. You don't need a 30-year agreement, an 80-year agreement. You just need that agreement in place as long as it takes you to satisfy your planning permission conditions. That links to restrictions over seller's land. Unless it's a very long agreement, you don't need to go into all of that. And I just want to reiterate, do check that your seller owns what it's purporting to sell to you, which goes back to Richard's
It's
point
so
of
important.
diligence.
Yeah.
So we do have a couple of questions just in the last
We
3 minutes.
do, don't we? Yeah.
Very exciting. I think definitely the first one's for you, Richard, or you, Penny.
Okay, question on nutrient credits. What is the scope of their application? Do nutrient credits apply to developments around SAC? So yeah, this is where you're dealing with a development in a site which is affected by nutrient the need for nutrient neutrality. And those when Natural England gave its initial advice on this, it produced a map showing what those vulnerable areas are to nitrates, to phosphates. And if you're creating a development which will add nutrients into river systems which are vulnerable and are in favorable condition because of excess nutrients, well, then you need to neutralize that impact. And that's why you buy these nutrient credits that neutralizes your impact. So, you know, what you're putting in, you're taking out through some other scheme. And that other scheme could be, you know, taking fertilizers off the land, for example. You're paying a landowner to do that, or to take a pig farm out of production, you know, that kind of thing. I hope that answers
But
that
just
question.
to add to that, it does apply to SACs. It's any, I mean, it can be SPAs or SACs that have this problem.
Exactly right.
And then
So
that second question, I think
Mm.
that's one for either you, Richard, or Penny.
Is the seller of units required to remove the reserved units from the register when they are in the reservation period, despite the fact they're not fully allocated to the developer yet? Okay, so the units, so that the shop window is the register, and it'll say what units there are, but they won't record them as allocated until the actual allocation has gone through. So you don't sort of there's no facility on the register to sort of grey them out or to sort of hold them back because of that. It'll show that they are for sale. It's just that if a developer contacted the developer for those, if the landowner for those, they would say, you know, that those units are now you know, reserved. So that's how that operates. I think there is a slightly better, I find, better website called Gaia, which is more like an eBay for biodiversity units. I don't think that has a bit more flexibility in terms of recording it.
But to be clear, when you use the word allocate there, that's the point at which you've paid, you as the developer have paid your balance and therefore title transferred to you. That's what we call allocation, because that's the word that's come out of the statute.
Exactly right. And the register is meant to be a single point of truth as to snapshot in time of habitat banks, what they've got to sell, and to which developments they have been allocated, and it lists out the planning permissions which they relate to. That's its simple purpose in life.
But I suppose that comes on to, that's a good thing to have in your allocation agreement if you're buying from a seller, and this is specifically biodiversity net gain. If you're buying for a seller who doesn't have loads of BNG units, in your allocation agreement, when you're paying your deposit, make clear that he's promising to ring fence the number of units you need for you, that he's not going to sell them to somebody else in that interim period.
Exactly right. And do you remember on that due diligence slide, I said, you know, you could check for double counting. Well, you could, if you're doing those sort of more in-depth things, you could look to see what the agreement is that underpins it. And, you know, a good agreement underpinning it will have provisions around double counting, preventing double counting. So that's, you know, something you can check if you're concerned about that.
Cool. So Penny, should we hand back to you for closing?
Yeah, thanks. Well, I think we've got to at the end of our 30 minutes. Thanks. That was a really brilliant, I thought that was brilliant webinar. I hope everyone else did. Thanks very much for tuning in. We're going to think up some more topics relating to this. One of them is tax. So we haven't yet announced the date, but we do want to talk about the tax implications of buying and selling nature credits and units. But in the meantime, thanks a lot for attending. Look on those links I showed you earlier to find the recordings, and hopefully get in touch if you've got any further questions. Thank you very much.
Have a good
Bye-bye.
night.
Thanks for your time, everyone. Take care.